This is Scott Berry from Berry Law Offices. This video is part of our continuing series on what courts consider when making decisions relating to child custody and parenting time. In my last video, I provided an overview of Minnesota's 12 best interest factors. Before exploring the individual best interest factors, it is important to understand where Minnesota law appears to be evolving, as the factors we will be discussing constitute a significant change in what courts have traditionally considered when deciding custody and parenting time. Traditionally, courts had considered a young child's bond with a parent who primarily provided the child's care as well as the wishes of the custodial parent. The current best interest factors abandon that traditional view, instead focusing on the child's needs and starting from a standard that is in the child's best interest to promote healthy growth and development between a child and both of their parents. In fact, Minnesota law now requires courts to start from the idea that both parents have the capacity to develop and sustain nurturing relationships with their children. This concept is to be applied by the courts unless there are substantial reasons that the involvement of both parents will not create nurturing, sustainable relationships with their child. There's also a concept under Minnesota law that a parent is to have at least 25% parenting time. Typically, the percentage of parenting time is based upon the number of overnights the child spends with their parent. However, again, based upon the belief that both parents in their child's life is the best interest of that child, we have been seeing more and more courts implement parenting time schedules that are very close to the 50-50 parenting time. In addition, there have been proposals made in the Minnesota legislature to increase the 25% parenting time standard to a 40 or 50% standard. With all this said, it is apparent that there is a movement towards sharing parenting time unless there is a real good reason both parents should not equally be involved in their child's life. With this in mind, we have seen and been involved in divorce and custody proceedings where, when the best interest factors are applied to the case, it is absolutely not in the best interest of the children for both parents to be equally involved. It is imperative that in each case, each best interest factor is analyzed and applied to determine the proper outcome of the case. In our next video, we will start examining the individual factors. If you have any questions concerning the 12 best interest factors or this video, please feel free to give me a call or email me.